Got about a little over a minute. So we are going to discuss property offenses today. There are more than a few, but your subject guide doesn't mention all of them. So we're not going to go through all of them. But in the end, I will give you, as usual, a little chart to form all the other offenses that are in it, just for your own knowledge sake. But as far as your exam and your syllabus and your material that's given by the university is concerned, there are many that are not, there are a few that are not being discussed. So we're not going to go into much details with those. The major ones are theft, as you'll see, burglary, aggravated burglary, fraud. Fraud is a broad, very broad, huge topic. So it's probably gonna, I'm assuming it's gonna carry over to the next lecture, which is fine, because we're not gonna rush through it. Excuse me. And today we're gonna start with the theft. First of all, we'll just look at the little chart here that I like to make these little charts because they are the visual aids are very, sometimes they tend to stick in my head more than a lecture or a written material. And so I hope this helps you guys a lot. Anyway, so Section 1 of Theft Act 1968 provides the elements of theft. It's from Section 1 to 6. They have mentioned different things and different variables to certain elements in different sections. Excuse me. So as usual, like other offenses, this offense also has an element of actus reus and a mens rea, and they have sub-elements. We initially, when we started the course, it started with the definition of theft. We used it as an example, and we carried it over to different topics. Today we are finally going to read about it in detail. Theft, what is theft? A person is stealing somebody, right? The normal or the general term that we use that is stealing somebody else's property. Law defines that a person is guilty of theft if he dishonestly appropriates property belonging to another with the intention of permanently depriving the other of it. Now, larceny, the offense of larceny is very close to it, and before the when the law was in development and before the Theft Act came out, it used to be larceny and theft were not much distinguished with each other. Larceny is taking and carrying away to permanently depriving the owner of their property. In the United States, we still use larceny, and we differentiate between larceny and theft here with a very tiny little element that differentiates the two, or the definition. So anyways, it is that when a person appropriates dishonestly with the intention, which means that the bad intention of not giving it back or permanently taking it away or using it to do something else, just basically depriving the owner of their rightful right to their own property in any way possible, with certain exceptions, is theft. What are the elements? The elements are listed over here. There is the appropriation. There has to be a property. The property should be belonging to somebody else. The mens rea element is the dishonesty, your intention to be dishonest with the property. And there is an intention to permanently deprive the owner of their property. Now, each element must be examined independently in order to get the conviction on the offense. And also, prosecution has to prove it, but prosecution must prove all elements in order, of course, prosecution must prove all elements in order for a conviction of theft to be successful. If one of the elements is missing, any prosecution for theft will fail. Just like other offenses, if It's prosecution's job to prove all elements of the crime, not defense, but all, or the absence of defense, but all the elements of the crime. If the prosecution fails to prove even a single element of the crime, that crime fails, okay, or falls. Now you also should understand that, as we have discussed before, that when a person commits an act or an offense, there are certain occasions when the prosecution may not be able to prove all the elements of the offense that he should be charged with, or we think he's going to be charged with. But sometimes it happens that one element is proven and the other is not, and that particular crime, because of that missing element, falls under another category. Yeah, so if the theft, for example, is not proven because of all the elements are not there, or he has some kind of defense, or something like that, then it is very likely the law is not going to let that person go, unless, of course, they cannot prove anything or any offense on him. They are going to pin him down with another offense that is appropriate at the time, if it's in the circumstances, of course. Very simple. It's short and simple. Okay, well, what we need to focus on here, other than the memorizing the elements like 1, 2, 3, 4 in the list, we also need to know what they all mean. In your guide, they have defined it in a different order, and I have put it down in a different order because, as you already know, I don't just look at the guide, I look at the other books too. What is appropriation? Appropriation, all the elements, just like appropriation, there are other elements too that are defined very, very widely, okay? But appropriation on its own, it's any assumption by the person of the rights of an owner amounts to an appropriation. Okay, it means that it's not my property, but I'm assuming all the rights that the owner of that said property is supposed to have with that property. He wants to roll it down the hill, he wants to hold it up on his head and walk around with it, whatever. It's his right to do whatever he wants with his property. But if I'm assuming all the rights that an owner can possibly, in his or her ownership, assume with that property, I am misappropriating that his property. Okay? You don't need to prove any intention to gain benefit necessarily. Now, if I steal somebody's pencil, it doesn't matter if I stole the pencil to sell it to somebody else, or if I stole a pencil to give it to somebody else, or I stole a pencil to just make a pencil helicopter or toy with it. It really doesn't matter. The point is that I took somebody else's pencil. I assume that I have all the rights to do whatever that owner of the pencil is supposed to do, and I am using and exercising one of those rights with that property which doesn't belong to me, right? These rights include anything where he has come by the property innocently. I mean, it doesn't have to be it doesn't have to be in a bad faith. It can be innocent as well without stealing it. Any later assumption of the right also to the property by keeping or dealing with it as an owner is going to be appropriation. Okay, for example, doing something with the property that owner has the rights to, like buying, selling, breaking, burning, give it to somebody to use, trade it in with, I mean, you name it, lending, whatever. It can be anything. It can be even destroying and anything, right? Really, you can put it in your shelf for keepsake. Yeah, I like it. It's pretty. It's pencil. It's yellow and it has lead and it has a little eraser, big eraser in the back. I like it. I'm going to keep it in my shelf. Still appropriation. In order to be guilty of theft, the defendant does not need to gain benefit from the appropriation, as I already mentioned. Hence, if defendant takes property from cash register of a company or from a store and try to donate it to charity, it's still going to be misappropriation. He's not using it. He's not doing anything with it, but he's using it as a charity. He's giving it away. It's not his money. It's not his to give it away. It's the company's manager's money or owner of the store, whoever owns the place or whoever owns the cash register. Whoever's money is it. It's their choice to use it, to donate it, to sell it, to give it away, whatever, to burn it, whatever they want. It's not my choice. I mean, it's not my right to take that money. Oh, he has $500, maybe he got one too many hundreds, and I'm going to give it to charity. No, you can't do that, okay? The motive and the results there, what you have done with the property really doesn't matter, and neither do prosecution have to prove what you did with it. The only thing that prosecution has to prove that appropriation has occurred. Okay. Now, what is later appropriation? I put it down here, later appropriation. Initially, it means that initially when the defendant come by the property and he doesn't have an intention to steal it at that time, but later he does or omits to do something whereby he assumes the right to the owner. For example, let's say your friend is going away on vacation and he wants you to take care of your car. Just, keep my car in your driveway for 2 days. I'll do that, and I'll take it. Okay. Now, I have not taken that car from him. He has given it to me he has made me in charge for a couple of days to, look after his car, whatever, just keep it safe in my driveway. If I'm going to give that car to somebody else, okay, so go, get me a carton of milk and you can take this car. That's appropriation. If you are going to sell it, it's appropriation. If you're going to start using it and painting it over, that's appropriation. Okay, not necessarily theft as yet, but appropriation. So later on, appropriation, later when initially it doesn't start with the intention to appropriate or misappropriate, but later it comes back. Yeah. Okay. Let me look at my notes here just a second. Yeah, so examples would be a borrowed car, or like I said, car given to the friend to keep it in their driveway for a couple of days while I'm out on vacation, and it's later sold or gave away to Salvation Army. I don't know how much you're familiar with it, but Salvation Army is a huge organization, charitable organization, and people usually they advertise that you donate your car to Salvation Army, and whatever amount of money they're going to sell it for, they're going to double that and give it to donation in your name. Okay, so that is Salvation Army. I just put it down as an example. That's appropriation. You borrowed the car and later gave it to Salvation Army or sold it. Any single right enough. You don't need to, if you have stolen that pencil, you don't need to just write it down or sell it or give it away or completely destroy it. No. Any right means that any one of the rights that owner has. Owner has multiple rights to his property. Okay, he can do whatever he wants with his property. The car that I borrowed from my friend, he has a right to put winter tires on it or big tires on it or like a woofer, those things that make really huge, really loud bass sound when the music is played. Put fire stickers on it, whatever, sell it or take the roof off. Any of those rights, any rights that can possibly an owner have associated with his property is appropriation. Just one right is enough to exercise. You don't need to do all of those. One more thing, that absence of consent is not an element to that crime. Okay, absence of consent is not an element to that crime. A valid gift is not an appropriation unless it is dishonest. So there was a case in which a person, I believe it's in your guide as well. I have not put it down here because I just used it as a general example, where a person married a man who was weak in his intelligence, it says, which means that he does not think or can make his decisions like a normal person with the general perception of an intelligence this person had. He was slow, and he married him, and slowly he kind of lured that person by getting him to give the defendant all of his property or some of his property. That is dishonest. He knew that that person is not in the perfect position to make a decision. He doesn't know from right to wrong. He doesn't know what he's doing. That's misappropriation, okay? It's not considered a valid gift. By consent, there was another case that you were giving for the absence of consent, that a person, an Italian student or a foreign student in Lawrence, she doesn't speak English, and she took a cab, and the cab was supposed to charge her 50 pence, but she gave her $1, and the cab driver said it's not enough, but she didn't know probably what dollars, coins, or whatever it looked like. So she handed her wallet over, and he took 5 pounds out of it. Here, if the defendant claims, which he did, that she herself consented the driver to take that wallet and take the money out of it, yeah, she did, but she only consented to the amount of money that was rightfully his, that was rightfully the fare of that taxi cab, not 5 pounds, just a 50 pence. Lawrence said, yeah, absence of consent is not an element of the crime. You can't just go by having that, say that she had consent, hence I didn't misappropriate. It's wrong. And similarly, a gift that has been taken by the donor, by the donee from the donor, when the donor is not in the right state of mind, for example, to give that gift away is considered dishonestly, and it will be appropriation. It won't be a valid gift. Now, what is the VFP, the bona fide purchaser? Does anybody know what a VFP is? Does anybody know? We haven't gone through in criminal with that one yet. Anyone? All right, so then a bona fide purchaser is a person who in good faith purchased something for money. Now, money can be any amount of money. It can be 1 penny to $1 million. How is it a bona fide? Because in good faith, because maybe he doesn't know that he is buying a stolen item. He is buying a property that belongs to somebody else. You know, so he completely has no clue that he may or may not be taking part in a crime in a way, or he's buying a property that doesn't belong to him, or it's a stolen property. That's a BFP. In short, we call it BFP. It's a bona fide purchaser. He cannot appropriate it, says. Why? Because obviously he is a bona fide purchaser. He has no idea, he has no intention, he has no clue that it's a stolen property. Section 3, Clause 2 defines how bona fide purchaser is not an appropriator. Now, last for now is the point in appropriation that court says, in the case of Briggs, court said that appropriation requires physical act. It cannot be automatic. For example, automatically transfer of the money would not be an appropriation. Okay. Okay. Let me see if I have anything else for appropriation for you. Okay. All right. Let's move on to the next slide, which is property. What is property? Property can be anything. Anything. It includes money. It includes All the real property, it includes the personal property, real or personal, including things in action and other intangible things. Money, coins, banknotes, even foreign currency is your property. Real property is all freehold land with exceptions. Exception will include, for example, easement or something like that. Personal property is any leasehold land and chattels. Chattels are the things, your computer, your couch, your table, whatever. Those are the chattels, all the tangible things. Freehold is the one that you own. Freehold is the one that you have a absolute right of ownership. There are other categories of the freeholds too, which is in the property section, so I'm not going to go in detail with it. It just means that I own the property versus I rent a property. Okay. Leasehold property can be either the real property that is the leasehold, or there can be other lease items as well. For example, I don't know how is it in where you are. Here, there's a company that sells that leases the furniture out and stuff like that. Simply, there is no complication in it, and you don't need to go in much detail in it. Anything that is you don't own is a lease, but you are using it for money is a lease, possibly. Okay, unless it's a gift. I'll explain it in the, if you still have a problem, I will give you an explanation note on it later on, okay? Okay. Now, intangible property. Tangible properties are the one, in simple definition, tangible is something that you can touch. Intangible is something that you just cannot touch, but you still own. For example, a share in a company. Yeah, you can touch the document that says I have 50 shares in Apple. But really, share itself, you cannot touch, okay? It's like one of those things that you own, you can't see, but you own it. A share in a company, there's a debt, okay? There's a debt. Debt is intangible. Copyright, I have a copyright in my book. I have a copyright in my movie. That is your intangible property. The trademarks, everybody know what trademarks are, right? You trademark a name or a logo for a company. So for example, for our school, SWBIL is our trademark name, and then our logo that you see in front or on our website and all that, that is what comes under trademark. A credit in bank account. Credit in a bank account and others. For example, there is a category of others, but no patent. Patent is the, for example, I invented a new machine that generates electricity from leaves, green leaves. It's my idea. I patented it. If anybody else wants to use an idea, they're going to have to use it under my name, not somebody else's. So you by law, put an ownership onto your ideas, okay, or your inventions, that's your patent. Okay, so, and then later on there are exceptions. What are exceptions? Any confidential information is an exception. It's not your property. For example, trade secret. Trade secret. What are trade secrets? Trade secrets are, I'm working for a company. How Apple's list of Apple has a list of their permanent customers. Apple has a list of how they manage their money. Okay, a little document, how they manage the money, how they get money in, their permanent buyers, their permanent people who are going to have a contract with them. Those are your trade secrets. Anything that relates to your trade that you do not want to make public is going to be your trade secret. It's confidential information. Obviously, you're not allowed to steal it and use it, but there are other offenses that you can be guilty of for that under. The case in point is Oxford versus Moss in 1979. The electricity, the corpse and body parts and services. There is a case on corpse and body parts as well. Corpses are the dead bodies. body parts, with any part of your body, limb that is after that, or the organs, that's not the property. You can't claim the right on it. Okay. Mm-hmm. Although you would think that the gas and electricity can be stolen, it does not amount to property. Property cannot be stolen by law under Lowe versus Lease, 1975. It was a case. It was where a person dishonestly uses electricity which another person is paying for, and for instance, by charging up a mobile phone, iPod, or laptop, they will not be guilty of theft. If you're illegally stealing money, the electricity from your neighbor, you may be charged under something else. It's not going to be theft though, because electricity is not considered property by definition under law. Okay. Next slide. What is of another? It means the ownership. Who does it belong to? Not me, but somebody else. Unless a thing is completely given up or abandoned, it belongs to somebody. Every property, everything that comes under the definition of property belongs to somebody. Okay, the concept of res nullius is very, 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 very narrowly drawn. Res nullius is then something that doesn't have the owner. There is no need to prove who it belongs to. Only the prosecutor needs to prove that it belongs to somebody else. They don't need to know it belongs to me. They just need to prove that this property does not belong to the defendant. Okay? So just because they cannot prove it, they cannot find the owner, the rightful owner of that pencil that initially we stole in our example, it's still theft. That doesn't mean that prosecution failed to prove the elements of the crime. Okay? Appropriation of your own property if someone else has a possession or control of it, or a proprietary right or interest in it at the moment of appropriation. How does that work? How can you steal your own property? I don't understand. Can you guys, somebody have an idea? What do you think it means? Anybody? Yeah. Could be impounded by police, correct? All right, so law says that it is not possible to steal your own property from your own self. If you are the sole person with the proprietary interest in the piece of the property, you cannot be guilty of stealing it. However, it is possible to steal property you own if somebody else has a possession or control of it, or a proprietary right or interest in it at the moment of appropriation, which means at the moment you are taking it away or depriving the person it's in possession of. Excuse me. However, by contrast, however, there was held to be no theft in the case of Meredith, in which the defendant took his car from the police yard, like Carl just mentioned, and found the police yard after it had been impounded by the police. The trial judge in the Crown Court directed the jury to acquit the defendant after ruling that police had no right to keep the vehicle from the owner. Now, if the police did have the right to keep the vehicle from the owner that was impounded by police at that time, it was illegally parked on an illegal parking, the spot where that's not parking, and or maybe you have unpaid tickets, speeding tickets, parking tickets, whatever tickets, and you haven't paid any of those, and by law, police can impound your car. Then police is rightfully by law is allowed to impound your car, and and at that time, if it's in police possession and you steal it, yes, it's theft. But in this case, Meredith, that Carl quoted, police has impounded the car, but the court said the police did not have any right to impound defendant's property. And the case came down to who it belonged to at that time. At that time, the car belonged to or should have been in possession of the defendant, not the police. Okay. Otherwise, it would have been theft. Okay. Abandoned property. The property, like I said, is not. It's very rarely completely without owner. If it's an abandoned property, it's not. It doesn't belong to anyone, and it cannot be stolen. Okay. How is property abandoned? How do you think the property can be completely abandoned? Even if I dropped a pencil somewhere and I have no idea where it is, I can differentiate between the millions of pencils that goldfish make, throughout the years. So does it mean that I have abandoned it? What would you think? How is the property abandoned? Oh, yeah. Yes. When you intentionally abandon it. Okay. Yeah. Law says that it is actually very difficult to abandon the property. Property is only abandoned if the owner is completely indifferent as to what happens to it and intends to give up his proprietary rights and interest in the property without conferring an interest to another person. My car broke down. It's an old car. It has all 4 tires are from a different company. It's a drag. I don't like it anymore. I have a new car, but I still own that old one. One day it just breaks down in the middle of the highway. I just leave it there. I'm still the owner. Until I say, oh my gosh, it's going to be so much hassle to bring this thing back and get it fixed and start driving it again or try to sell it or give it away. I'm just going to leave it there, and I don't care whoever takes it away. It's abandoned. Okay? I do not want to confer to any proprietary rights or interest in that property. Sometimes old furniture people just put out in their driveway outside and say, free, take it away. They have completely abandoned the property. It's not theft. Okay? But I have put out a bag full of clothes that I intend to donate to Goodwill. And I have put it down, donation for Goodwill. So Goodwill truck is going to come by and pick it up from my driveway. I have put it down outside. It doesn't belong to me anymore. And Goodwill hasn't picked it up. Do you think that property is abandoned, and if somebody steals it, it's going to be theft? Anybody? Yeah, I have not completely given up the right. I have actually assigned another owner for it. Goodwill is another owner. Okay. Although I am abandoning all my rights in it, I'm giving up my rights, proprietary rights and interest in the clothes, but I have given it to Goodwill. It doesn't belong to anybody else but Goodwill. I am giving it to Goodwill, right? Exactly. So I intended for it to go to goodwill. So I am not giving up the right. If I have left things out on my yard for the authorities to collect at the end of the the week, there's a point in case on that, Williams versus Phillips, 1957, and the divisional court in that the case was that there was property was no longer wanted by the owner and it was left outside as refused for the local authority to collect. It is not abandoned and does belong to another. Okay. Divisional court held that as refused is left outside for the specific purpose to be collected, it remains the property of the householder until it has been taken away. And the employees of the local authority collect the refuse and place it in their dust carts, the refuse becomes the property of the local authority. Therefore, the refuse belongs to somebody at all times and is not abandoned. So you see the chain of the ownership is not broken. Okay, it's going from my hands to Goodwill's hands. It's not broken, just like that case, the Phillips case. So remember, unless it's completely abandoned, unless I have completely abandoned it, it's not abandoned. What about the property of deceased? A person is dead. There is $50,000 on his body, in his pocket. Somebody steals it. There was a case on it, if you guys remember. What about that? It's theft. How is it theft? Because there could be a will. Yeah, that's exactly right. There could be a will, there could be a gift, there could be interstate. There is always interstate property. Okay. The case that they have that I read last night about it was Filament versus Balion in 2002. It happened that there was a drug dealer who died, and he had 50,000 pounds on his body, and the two defendants. Yeah, and the two defendants stole it, and police said it was theft. But the trial judge at the Maidstone Crown Court ruled that the property did not belong to another at the time of the act of appropriation and directed the acquittal on the charges of theft. Why did he do that? Because, first of all, they said the owner property should belong to somebody who is alive, okay? And in this particular case, it was not just that. It was that it was the money from an illegal transaction. It was already somebody else's money. It was not drug dealer's money. So how can you steal from the person who is not even the owner of the property, right? The issue arose that who did the money belong to, and it wasn't satisfactorily resolved in that case. The court said that it's clear that money could not belong to a person who is deceased. And they also said as the proceeds of an illegal transaction, it did not belong to the firm, the local drug dealing group that was working. And the trial judge ruled that the money could not be shown to belong to the estate of the deceased because this would necessitate proving that the estate of the deceased person was capable of having possession of money that they did not have. Okay, so it comes down to how do you possess your property? Even if you are dead, do you have a estate because when you die, your property automatically goes to the estate. Estate is It's like a, it's not imaginary, but they call it that it is the owner when you are dead. Your estate can be your money, your real property, and if you don't have a lawyer or if you don't have a beneficiary or the trustee of that property, so to speak, not in the real trust though, then the government or the state comes out and take care of the property and distribute it between the heirs appropriately. So if the person is died without a will, without distributing his property during his lifetime, it's called an intestate. Then the state jumps in and they try to distribute the property. And it's a little note on the property law. Yeah, so property of a deceased, if it doesn't belong to the deceased, you cannot steal it from the deceased. You may steal it from somebody who's the rightful owner, but not from that particular person who doesn't own it. And since he doesn't own it, the estate cannot have the possession of it. So that was decided in that case, discussed at least in that case. What about the equitable interest, like trust property? When you make a trust, you have beneficiary, you have a trustee, okay? The beneficiary is the one for whose benefit the trust is being established. Trustee is the one who takes care and manages the trust. A trustee and the beneficiary, they both own or possess the property because they both have some rights. A trustee doesn't, however, have a right to use the property, and if he tries to steal from that beneficiary, that's theft too. Beneficiary, however, has a right. Now, sometimes it happens that you do not have a beneficiary left. Beneficiaries are dead. If there is nothing in place in the will on that, it's still not a trustee's property. Trustee is only the caretaker of the property, remember, okay? It's still going to go through the same procedure that the intestate or the inheritance law or the will. However, most likely if you have a trust in place, you are almost always going to have a will, okay? So a trustee can be guilty of stealing trust property because he's not the rightful owner. The beneficiary is too. What if the trustee is himself is the owner of that property, but he has put all his property in trust, and he and his son or the kids are the beneficiaries? In that case, it's still going to be theft because at that time of the appropriation, if the court will look at whether he was working as a trustee, using the property as a trustee, or as the beneficiary or the owner of the property. Okay, so that's what it's going to come down to. I don't think they're going to test you on that particular note, but just as a side note for the reference, keep that in your mind. Property received for a particular purpose. Where the title to the property passes to the descendant before the dishonest appropriation of the property. The property does not belong to another and can be no conviction for theft. Okay. However, there are two specific situations where the law says where the property is deemed to belong to another, where the person receives the property from on an account of another, and it's under an obligation to the other to retain and deal with the property, or it proceeds in a particular way. The property or proceeds shall be regarded as against him as belonging to another. I have given you the authority to look after my property and then sell it when my son or my daughter turns 21 and give the proceeds to him. Yeah, I'm going to clarify. I'm getting there. So the example is that I own a land. I have made you, Carl, the trustee or the caretaker of my property. Okay, it's a farm, whatever. It has lots of animals on it. I'm not there. You are the one who is taking care of the property. You are the one who is feeding the cows. You are the one who is selling the milk of the cows. You are the one who is selling the grapes, whatever is going on the farm. But you're not the rightful owner. You are just, if the property is given to you for a particular purpose. And the purpose is to take care of the property until my son turns 21, and then you're going to give it to him. Okay? And or you're going to sell it and give it to him. Okay? or the lawyer who got the property from the owner, that to keep it with him until the value goes up to this particular amount, and then you're going to sell it. You only have that, you have given that property by the owner with his consent, but not for you to keep. The idea is that you're going to use it for a particular purpose, generate money from that farm, okay? And then you're going to give it to somebody else who the owner wants to give. Is that clear, Carl? No? Shall I give you another example? Which earlier point, the Equitable Trust? Okay. There are two types of trusts. The one trust is that I have some amount of money that I want to save for my daughter when she goes to college. Or let's say I have a grocery store, okay? I make you the trustee of the grocery store. Okay, I say, Carl, run this grocery store, and all the proceeds from this grocery store are going to go to this bank account, and my daughter is the beneficiary. So every month you're going to give her $500, and once she gets to the college, then you're going to sell the store, or whatever the money is we've gotten from the store and saved it, you're going to give it to as the fee to her college. Clear? Clear at that point? Okay, that's a trust. That is the trust that I have set up for my daughter, okay? Now you are the trustee. You are not the owner, although you have every right to use that grocery store. You are running it, you are paying the bills, you are cleaning it, you are, when nobody's there, you're sitting on the revolving chair and with your legs up and sipping your coffee and watching TV. Anything you're doing, you're using it as your own, but it doesn't belong to you. That's trust. If you steal from that, or you sell it to, you think that your daughter, my daughter is never going to go to college, and she needs more money now because she wants to buy a huge mansion in Beverly Hills. You're going to sell this store, okay? Although you want to give the money to her, you steal that money, or not even to get that point. When you sell that grocery store, before it's time to sell it, that's you're taking the property away from her. Or I have asked you to give my daughter $500 every month. You take $550 out, and you consider, I worked so much for this person, I should get some money. It's my pay. That is theft too. You do anything with it that an owner that I am supposed to do with my property, okay? That is not within your job duties. That's going to be theft. Now there is another kind of trust, which is the equitable trust. What happens is sometimes an equitable trust is set up by the court or by the state when you think that somebody else is going to usurp the right. For example, I have, you are the agent who is going to show me, who's going to sell my house to somebody else, okay, for $100,000. What you do is you sell the house for $150,000 and take that $50,000 to yourself and you buy a car. That is my money. That's not your money. The court is going to put equitable trust on that $150,000 or that $100,000 and the car that you bought for $50,000. That is called equitable trust. In contract, you must have studied that what do you call it? Equitable benefits when taken away, so you are not unjustly enriching on my property. You are not getting the benefit of $150,000 that you got from selling my property. So it's not a real trust, but good. But the court is going to put a trust on it, so just to make sure that you don't misappropriate with my money, and since I'm the rightful owner of that all $150,000, I should be the one who's receiving that. Okay? Okay. Anybody else has a question about that? Anybody else not clear on any other points at this point? The reason I put all these little pointers here is because each section in your book deals with these specific types of transactions. Why is that? Because, like I said, when the law develops, new situations emerge, and they have to make an addendum or an addition to the originally stated law, and that's how they keep adding to the law with every situation that is come out to play. If tomorrow there is a new situation that comes out and they have to add it to the tab, they're going to add another clause to that section and make it a new pointer if it's necessary. Okay. Moving on, property received for a particular purpose, we already discussed it. Property obtained by mistake. Anybody who is not the rightful owner of that property, but it has been obtained by mistake, is going to be theft. For example, you painted my house, and we had a contract that you're going to paint my whole house within 1 week, and I will give you $1,000. Okay. Instead of writing a check, I wire you the money through bank, and instead of wiring you $1,000 that I was supposed to pay you for painting my house, I wire you $1,100 by mistake. Okay. Or $10,000, whatever. That overdrawn money that by mistake has gone to you, if you use it, you don't have intention to steal it at that time. I mistakenly given it to you, but it's not yours. If you don't give it back, there's the obligation on your part to give it back or let me know, hey, listen, you have given me way too much money. I only need $1,000, and you use that money without telling me. That's going to be theft then. That's going to be appropriation afterwards. Okay. Okay. A golf course. A golf course. If any of you play golf, you should know that when they play golf, there's some areas where they have water. There's some areas they have their little shallow sand ditches. So the balls that are being collected in the water pond there that the owners of the balls could not take out, and I go in there and I'm making a beautiful sculpture out of golf balls, and I steal 5 balls from there. Am I stealing? Am I committing theft? Anybody? I would think so. Okay. How? The owners don't want it anymore. It's just sitting there in the pond. They know it's there and they're not going to get it back, and they don't care to get it back. They went out and buy new balls. Yes, that's correct. The golf course is the owner of that pond. Okay, and they are gonna, if there's a distinction that is the golf course's property, yes, and any indication that it belongs to the golf course, the pond where the balls are, it's not mine to take. It's still, and it's, yes, it's still it could be still the owner of the property if he doesn't, unless he doesn't want the balls anymore, but then the balls belong to the golf course. This example was taken from the real case. So there are different variables of how you can see in different facts, and you probably are going to get a fact pattern on that. Just remember to analyze first who is the actual owner of the property before you start analyzing the appropriation. And once you have determined that there is another owner of the property, then obviously there's going to be an appropriation. Okay? Unless there's the owner of the property, you cannot have an appropriation. So go through the ownership, then the appropriation, okay? And then you're going to go to the other elements. So the mens rea element of theft, dishonesty, the first one. There are two aspects of it as your guide describes it. There's a negative aspect that is defined section 2.1. Really means not to be dishonest, which they are really making it complicated. It only really means that unless you are dishonest, you don't have mens rea. So the law says that a belief that he has in law the right to deprive of other of it on behalf of himself or of a third person, or a belief that he would have the other's consent if the other knew of the appropriation and the circumstances of it, or a belief that a person to whom the property belongs cannot be discovered by taking reasonable steps. So really, they are telling you, in short, that unless you know that by law I have a right to deprive another of my property, the police, remember the police who can impound your car for not paying the ticket? Either I can do it, either police can do it themselves, or they're going to get the impounders to do that. That would be third person. I believe that he would have others' consent if the other knew of the appropriation and circumstances of it. So we have a mutual understanding that we live in the same house, and I've bought the fire extinguisher, and if there's a fire coming out of the stove, then my roommate knows to use the fire extinguisher to extinguish the fire. Okay, that's what they're talking about. If you knew that there's going to be consent. So as you know, and if it's going to be consent, it's not going to be theft. The third one is the belief that a person to whom the property belongs cannot be discovered by taking reasons. Nobody knows who is the owner of that pencil. They are searching high and low. Somebody is the owner, and owner is not turning up. It is that the same theory of the complete abandonment, that there is no owner then, or it's undiscovered, then which means that after a certain point of time, which probably case-to-case basic law can determine, then the property is declared refinalious, which means that a property which doesn't have any owner, and then it will taking it away would not be appropriation. Now it says the prosecution will need to prove to the jury without a reasonable doubt that the defendant was dishonest at the time of appropriation. It's one of the elements, not saying that the defense is that no, I wasn't dishonest. These could be taken as in defense. But the jury has to prove, prosecution has to prove that there was dishonesty present at the time of appropriation. Now there is another, the positive aspect of it, the ghosh test. It's mentioned, as mentioned in your notes and in your guide. What is a ghosh test? Let's check my notes here real quick. Okay, the ghosh test is that the jury must consider whether what the defendant did was dishonest according to the ordinary standards of the reason or of the reasonable and honest person, the objective test. We have read about objective tests so many times. They are really distributing this test between the objective standard and the subjective standard. And they say that if yes, the answer is yes, then they are going to consider, jury, whether the defendant realized that reasonable and honest people would regard it as dishonest. That is your subjective limb, it's called. I have a little graph for it. Let's see, there. That's the ghosh test. The jury will look at will ask that would the honest and the reasonable person regard what did defendant did as dishonest? If the answer is no, that means he is not dishonest. But if the answer is yes, then they're going to ask the other question. Did the defendant realize that the honest and reasonable person would regard it as dishonest? So the other people and also what the defendant is thinking. If the defendant doesn't realize it, then there is no dishonesty. If the defendant does realize it, it's going to be dishonesty. Okay? I was hoping to go a little bit further, but it didn't today. We are all out of time, and we're going to carry on from here in the next lecture. Now, you all should know that I'm going to give you a few topics to look at before, but next week we're going to have a mock exam. It's really imperative that everybody attend that mock exam. If you cannot attend it in the class, with the time that I will prescribe that you can submit your answers within this amount of time, please do submit your answers in that amount of time. We are a little behind on our mock exams. Mock exams are very important. They train you how to actually take the test. They also tell you that what can possibly be asked in the test, the examiner's frame of mind. And after that, when I upload the sample answer of that particular question that you guys are attempting, do look at it. And even though I can give you feedback, but you should also compare yourself with it too. And read through that answer and then go back and read your own answer to see that what is it that you missed and how did you miss it. Okay? If you have any question about any of the concepts, it's kind of tedious to go through all these little topics in one topic, subtopic. And let me know, shoot me and send me a message or write down on Facebook, and I will work on it, and we can discuss it next time. I will write it down. I will make a post about it and write it down by tomorrow, at the latest by Monday. I will try to do it tonight. Okay, I will try to do it by tonight so you guys have all this and you can read through those things. There will be not more than 3 topics, and I'm just gonna plan the question accordingly, so you don't have a lot to read. But we are approaching really fast to the exam time, and it's time that we need to pick up on our exam taking skills. Okay. If you don't have any other questions, you are free to go enjoy the rest of your weekend and send me a message with any questions, any confusion you may have, and I will try to answer it as best as I can. And if necessary, we'll cover it in the next lecture.